welcome Professor Vijaya who's kind of been, I would say, of course, she's a, a leading scholar in corporate law and done a lot of work around competition. But she's also been a very major friend of Nalsar. She came here and she was our Gyan scholar. And we have, like, you can say, a very long association with her, somebody we look to for, because sometimes we feel we are accused of not doing enough in corporate law. So every time when we want to be showing people that no, we are doing serious work here, we turn to Vijaya and ask her to sort of lead us from the front. And it's in the same spirit that we've invited you for this entire series that we are doing, which we've entitled Flying Research Kites. Primarily, the moot point is this, that to decide what you have to do research on, also you need to research. And how exactly that research should be carried on, what are the kinds of possibilities, what are the issues which in the whole realm of corporations which are unexplored, need to be, people need to do work in it but have not done. So it's in that context that this entire series of workshop has been planned. And I couldn't think of anybody better than you to lead us here in, there are a fair number of students who want to work in the area of corporate law, also want to be looking at what are fresh angles from which they can be researching corporations. So it's that's exactly and let's see, that's my basic request to you as to, and then the conversation which will lead up from there. Also, I'm hoping that it becomes in some ways reciprocal, because what we have found till now is that because you're getting people around you who are interested in a particular field, the kind of questions they tend to raise sometimes gets a speaker also to think, okay, this is something worth looking deeper into. So that's why we're calling it a kind of a conversation that is happening between an expert in the field and younger people who are interested but are requiring guidance and mentoring. So I very warmly welcome you, Vijaya, to this session, and hope that all of us have a rewarding morning.
Thank you. Thank you very much, Amita. Firstly, I'd really like to really formally thank you, Amita, for all the things you've done. This is a really inspirational set of workshops you've organized. It's great. You also are an extraordinary ball of energy. You've kept things moving. The way you've brought this together is just an indication of how you seem to do that. The second thing you've always done is kind of try to bring ideas, and whatever the idea is, you have let it fly. You've let it be discussed in a bit of an open forum, teased it out, asked people to think about it. And I always remember you talking to me on a number of occasions more than a decade ago about a couple of those ideas. And I found those conversations with you really fruitful. So you do challenge, you do ask us to view things differently. All of the things that make you the great scholar that you are, and the inspirational academic that you are. So it's a pleasure to be here. First, and also I've got to say something about having been in Nalsar as a Gyan scholar. I think it was in 2016, and the quality of students that you had, who were really top notch. And this is to come back to what you said, which is this kind of conversation is two-way. In the comments you get, in the way you get to pause and reflect, there are things that you have never thought about as clearly before. And certainly that session that I had at Nalsar did make me think about a lot of things about corporate law, because at that time it was being introduced, but the implementation was poor. And the students were so much aware of things on the ground, and they were asking questions about it. But like most things about corporations and corporate law and competition law, there is work there, and perhaps it takes, it becomes a primary motivator over research. If I can ask for the next slide, please. But what I would like to say is that corporations are really worthy of research. There is so much you can do with them. I just wanted to talk briefly about some of the things that make them worthy of research. The first idea is that a corporation is this artificial person. It's a total legal innovation. It's based on those principles of agency. It's based on those equitable principles. All of those different principles are called upon to make this corporation function. And these legal principles are constantly changing depending on the economic doctrine of the time and the political agenda of the time. So the idea that law is in some way stationary and doesn't reflect a context is something that is proven wrong just by studying how corporations have moved. So the whole notion of how a corporation comes into being, the notion of it being a separate legal entity distinct from its managers, the fact that you can have a corporate group, but each corporation is in fact a different entity from another in which it has 90% of shares. All those sorts of issues are worth scrutiny. Another thing I wanted to talk about and why they're worthy of research is history. The corporation has morphed so much over time. One of the old corporations we'll always think about is, of course, those corporations that were founded in England to become for a particular public purpose, such as to build canals, the Suez Canal Company being one example. And of course, the British East India Company being another example, which shows the way in which the corporation is part of the colonial project, was there to further political ends, and became an important driver of these ends. So the way the corporation became part of this project is something that's been picked up by many scholars today, and they're trying to tease out how can you get a corporation to work in the world in a global context and to be responsible, to be in some way accountable. Every government today is actually facing it in the way they're trying to make corporations accountable, such as Facebook accountable or Google accountable for the information that's being transmitted. So corporations are worthy of research again, just by seeing how they've morphed through history and become such an integral part of our lives. Which takes me to this third point, that the important role corporations play in our lives makes them so worth critiquing. Behind every product and every service we consume, there is this soulless, lifeless, legal entity called the corporation. The manufacturers of the clothes we wear and the nuclear bombs that are important for countries, the entertainment we consume via Netflix, how we invest our money, whether it is in Tesla as an environmentally sound company or in arms, all of these involve corporations. Every religious organization now is a corporation. So churches have realized the importance of protecting themselves from tortious liability and taken on the corporate form, not just now, but quite a while ago. So we're also relying on corporations desperately now to help us with vaccines. We're looking at them to disperse aid to people and nations. And now we're also looking at them to address climate change. So corporations are actually worth critiquing because they've become so important, not just to how we consume right now, but also how we will go about addressing the big challenges we face in the future. So it is worthy of research, is really the point I want to make. If I can have the next slide, please. Thank you. Here I want to take you back to Professor Danda's presentation some time ago, where she talked about how to go about researching a topic. In that presentation, which she was kind enough to share with me, I pulled out these 4 points that Professor Danda made. in order to reiterate them in the context of researching corporations. Firstly, the main thing is to find an area that interests or excites you. As I've just mentioned, there are so many aspects of corporations that are exciting. The separate legal entity itself is something that's worth researching. For example, the idea that you can lift this veil of incorporation to attach liability in certain instances is worth investigating. Chief protected groups among those that where you can raise the veil of incorporation to attach liability is creditors. The fact that creditors are protected and the fact that this became something that the courts determined in the 20th century and became legislated in the 20th century is really worth exploring, even though the corporate form was founded in the 19th century. The modernizing concepts of law and economic scholarship became part of the way in which a corporation was conceived in the 20th century. And this progression of protecting creditors itself makes such an exciting area of a study. Another area of study that is worth exploring is jurisdiction, where a corporation is incorporated and where it carries out its activities and where it might cause some kind of damage. And of course, the Union Carbide case has a long history and it has a long litigation process that has brought some of these issues to the fore. More recently, the Shell case in Nigeria went all the way through the courts in the United States to look at jurisdictional issues of whether a corporation that is registered in the United States can be liable, can be held to be liable for harms that are caused in another jurisdiction. In this case, it was the harm in Nigeria. So how a corporation can actually use jurisdiction to avoid liability is something that is certainly an area that could excite people and that could be something that could be investigated further. As Professor Danda pointed out, the main and the key challenge when you're researching corporations, when you're doing postgraduate study, any study in any area at all, is to firstly find the area that excites you, but then to focus in on a topic. So if you're looking at these principles of a corporation, if you're looking at the veil of incorporation, you've got to be able to actually find a specific topic that could be corporate groups and liability within corporate groups. It could be the jurisdictional issues. It could be using a case study to try to expand out the way in which it might apply and the general principles one could gain from it. So the area could be a corporate responsibility or jurisdictional liability, but you've got to be able to bring it down to a particular topic. Is it environmental harm you're looking at? Is it tortious liability you're looking at? Is it a particular jurisdiction you're going to be actually examining? Is it a particular kind of a wrong that you're going to be looking in relation to some sort of country's some kind of an example that might be a key example for you? So it could even be fishing rights that corporations may be able to access. So really finding the area, but then coming up with a topic is really the key, which involves a lot of reading until you can find a topic that you can actually live with for the period of your candidature. After you find that topic, once again, you've got to go further to find the question that interests you. It's only by doing that that you can actually come up with the research question. the question you find is going to be something that is going to be of community concern. It's also going to be something that policymakers are going to be considering. Students are often fascinated when they look at corporations at CSR, corporate social responsibility, and the way in which this is being undertaken by corporations, but what governments do to further this, to make corporations actually firstly state what their responsibility could be and provide ways in which this could be realized. Right now, international corporations are addressing so many issues that face us, mainly because governments themselves are unable to face them in a unified manner. Often, governments are so worried about how another power is operating. And right now, of course, all eyes are on China and how China is operating, that they actually cannot come down to deciding how to act in a unified way to address this hugest problem we have now, which is of climate change. So it has been something that has been handed over to corporations to come up with a solution. And a number of the corporations are actually deciding to adopt the climate scenario analysis that's being put forth by the task force on climate disclosures. And they are actually reporting on how they are reacting to climate change through using this scenario analysis. But that isn't sufficient. What a corporation does and what it says it does requires others, stakeholders, to critique, to consider, and to question. That is how accountability and democracy can really work. So research in this area is important. Students are interested in this idea of CSR, but again, what you have to do is look at CSR as an area, find a topic within it, and then find a research question that can then keep you occupied and get you to focus and start your research. Can I have the next slide, please? This is where I just want to briefly look at positioning your research. The important step when you're considering researching corporate law is to read broadly. And corporations research can be found in many, many areas. They're in all sorts of journals. So they're in philosophy journals, which talk about the morality of a corporation. They're in journals to do with management, because it's all about how a corporation is internally organized that can actually bring about a morality within the people who work in that corporation, which can actually bring about greater accountability within the officers who work in the corporation. It is in journals to do with organizational theory. It's in journals to do with health and, of course, law, socio-legal journals, international law journals. So corporations research is found in all these journals. And it's by looking widely that you can actually come up with something that interests you. So the first thing to do is to identify the literature and to look at these journals to see the kind of writing that is happening in these journals. But I really encourage you not to limit yourself just to legal literature. You have to consider other points of view. As it has been, I'm sure, mentioned many times, law is constructed knowledge. It is based on the idea that there is no one objective truth, and it's actually a perspective. It's a contest between different perspectives, and it's simply reflecting a particular perspective at the time. It's important to acknowledge that, and corporations is one where it's very clear that that applies. Professor Parasha's presentation on researching family law called on you to adopt a critical perspective as a good way to see what a critical perspective to critically assess where the law is heading and what it's doing. And I would say in the area of corporate law too, this is really a good way to see what is happening, what are the different points of view that are present. Here, perhaps I will mention briefly a student that I'm currently supervising, who's a doctor, who is looking at bad health outcomes that are resulting from the way in which competition policy has been formulated. His argument is that the way in which market power is allowed to consolidate among corporations and the kind of vertical, horizontal, but also other consolidation of power that can happen within a market has the aim of producing goods at a pace and increasing consumption at a pace which has bad health outcomes. By using an empirical study, which is looking at consolidation of corporate power in different jurisdictions, he's primarily looking at less developed countries, he's able to map out that certain types of mergers are allowed and are not even regulated by competition policy and competition laws because they are not horizontal or vertical, but they end up consolidating the power of the corporation in many markets, which results in increasing the consumption of a good such as what he's primarily focusing on is fast foods and, of course, soft drinks, highly sugared drinks, to try to show that over the last 20 years, this concentration has been paralleled with bad health outcomes. The way in which I can argue that this thesis by that particular student applies here is he's not limiting himself to legal literature. He is relying on health literature. He is also looking at concentration within markets, looking at competition policy, but he's looking to ask what is the actual objective of competition policy trying to regulate corporations. What are they trying to achieve here? How are they looking at benefit that is supposed to come about from regulating corporations? And here he is acknowledging the externalities that result from corporate conduct. In this case, is bad health outcomes that seems to be outside the reach of the law. So the question that Ben is asking is, should this be the case? Should externalities that come at such a huge cost be ignored by regulators when they're thinking about competition policy and controlling and regulating corporations? So the way in which looking at interdisciplinary scholarship can assist you to critique existing structures is something that I feel has been neglected for a long time by people who research corporations, and it's something that you must attempt to do. The second question that I have brought about here, if I can read this, is, that's right, ask the questions that address the issue in a new way. This is a point that is something for you to consider. But when you're addressing the questions in a new way, you have to think about theoretical frames that you could apply. Often people think that they just have to go with one particular theory. I beg to differ. That might be the case, but in a number of instances, people are able to bring about a number of different theoretical perspectives to show how their research can be contextualized and can be viewed to show the way in which you can actually reflect on what the corporation is doing. So I would encourage you to think about theoretical frames that could help you in taking a critical look at a corporation. And in just a few minutes, I will explore two of these critical frames in a bit more detail. Excuse me. There are, of course, many approaches that you can consider when you're looking at researching corporations. And one is, of course, is it comparative? People seem to think that, you know, a lot of reform seems to be built on, let's just cut and paste. So let's take a reform that's happened somewhere. For example, the reform that is that's happened in India about a portion of funds of specific listed companies going towards CSR, and let's just cut and paste and put that into another jurisdiction without looking at the context of that jurisdiction. So the comparative approach, if you're going to adopt that, still has to look at the country in which you're thinking of applying this particular reform that you're considering. You can't just consider adopting a reform and applying it somewhere else without thinking of the political, social, legislative possibilities in that country. And I'll just come to that, briefly introduce another student of mine who has done a thesis examining transplantation of corporate laws in Vietnam. And I'll come to that in a minute, and the kinds of issues that he confronted when he was looking at that topic. So simply comparing an approach taken in one country and trying to apply it elsewhere is going to be fraught without a more meaningful consideration of the context. As I said earlier, an interdisciplinary approach, as the one I explored before with health and competition law and how it regulates corporation, is something that's really valuable. Different kinds of interdisciplinary approaches or perspectives, of course, include the historical perspective, which shapes a lot of what we have today. And in that context, looking at how institutions have a path dependency and how historically the way in which an institution was formed and the kind of critical junctures it faced and how it is operating today is something that is really valuable to apply when you're critiquing corporate conduct in many different ways. So that in that interdisciplinary approach, which is looking at historical institutionalism, for example, is something that is relevant that you could think about. Another approach, of course, is empirical study, and I think you will all be very well aware of the qualitative and quantitative methodologies that apply here. They can be so useful in corporate law. So if you're looking at the success or effectiveness of a particular measure, so you're looking at how effective is shareholder resolutions or shareholder protests, it's quite easy to look at annual reports and to find out how many of such resolutions were put forth, how many of these passed, and to actually do a quantitative analysis by looking at public documents. That's really a boon to people researching in corporations, that they can actually look at these annual reports and collate data which can assist them in analysis. If you are looking at something like climate change, for example, and how corporations are responding to the challenges of doing something about climate-related risks, looking at their annual reports and looking to see whether they are actually disclosing environmental, social, and governance issues, whether they're actually adopting scenario analysis to try to disclose on climate change, are all things that can be collated when you're looking at corporate research. And it's something that's really so useful for somebody who is writing a thesis, to be able to bring in that hard data and to bring that in and to use it in conjunction with theoretical frames to make an argument. So that is something I would encourage people to look at, to explore further when you're looking at corporate law. And of course, there is also qualitative research, using forms of coding when you're looking at texts, such as disclosure documents on websites of corporations, such as statements that are made or policies that are disclosed by corporations, particularly transnational corporations, and thinking about a textual analysis of how they are disclosed in different ways in different jurisdictions. And there is different forms of disclosure in different jurisdictions, is a wonderful way to consider how corporations are actually being regulated and how they are responding to regulation, to see whether their approaches differ from one jurisdiction to another. So empirical research is valuable when you're looking at corporate law. Another example that you could consider is a case study approach. And this could involve looking at one or two case studies as examples to tease out some of the principles that you are toying with. So, for example, let me just think about something like the possibility of protest, a citizen's protest against corporations, and whether or not that can be effective. In that instance, a case study approach that looks at a successful protest by citizens which brought about corporate change can allow you to look at some of the specific, I suppose, synergies that existed in that case study that was able to bring about this positive outcome. And with that kind of analysis, you'll be able to examine and come up with principles that might guide positive citizens' interaction with corporations. And you might be able to contextualize it and talk about what kinds of stakeholders and interplay between stakeholders has made this possible success. So one of the students that I have supervised has looked at protests in different countries by citizens' bodies. An example that she looked at was in Russia, and the example of protest in Russia and protest in Australia, and tried to come up with some basic principles on what you need for a protest to be successful and to bring about change in corporations. So a case study approach too gives you just an anchor to be able to base your analysis on, and allows you to focus, come back to this particular set of circumstances to be able to generalize further in tackling your research question. So in talking about positioning your research, what I'm trying to tell you really is, yes, there is a need to look broadly, to read widely. There is a need to have a theoretical underpinning, and a theoretical underpinning is applicable in all circumstances. It is essential, even if it is going to be a positivist one. Nevertheless, it is essential. And the others, comparative, interdisciplinary approach, empirical, case study, are all methodologies that could inform the way in which you go about researching corporations, go about tackling your research question. I might go on to the next slide, please. So here, I want to spend just a couple of minutes talking about the research question, this is an ongoing issue for people who are researching anything at all at postgraduate level. You know, when they start researching, it's like a bit like swimming. There is this beautiful big pond out there when you start your research, and you just adore it, and you dip right in and swim out, and you're just enjoying everything in your way. The waves, you're enjoying the shoreline getting further and further. You're enjoying the fact that you're alone, and you're enjoying the current, you're enjoying the blue sky, and you're absolutely in a blissed out state. Usually, after a little while, when your supervisor then starts saying, what is the research question, you start panicking, and you really have to come back and try to figure out how you're going to get back to shore and how you're going to actually start tackling the real question. So, but enjoy, I must say, enjoy that time, that free time of just dipping into all the literature, of dipping into all the journals, and just saturating yourself in all the scholarship that's around. But somewhere along the line, you have got to face the research question. And the main thing about a research question is that it must be a question. But the second thing about a research question is it cannot be answered with a yes or a no, because then you would have a very short thesis. So you've got to be able to ask the question in a way that can allow you to explore the issues. So something like, how effectively has the area been? How does history inform the current position taken by? How has implementation succeeded in? So these are ways in which the question can be formulated that doesn't end up with a yes or no answer, and can help you to discuss a number of things over all those thousands of words you will be writing. The other thing about your research is that it's got to fill a gap in the literature. So your research question is not something that's been dealt with ongoingly by many other scholars. It's got to be something that is tackling a gap in literature. So you might be looking at something about independent directors. There's so much literature about independent directors out there, and you might be looking at that in the context of India. So it might be that how effectively does the principle of independent directors improve accountability within the organization or enhance corporate governance? So you could frame it in that way, which is filling a gap in the literature. It's acknowledging the supposed role of independent directors and how they contribute to improved governance, but it's tackling looking at that big question in your context. So it's got to fill a gap in the literature, and it's got to tackle a current problem. The important thing about tackling a current problem is that it is going to be much more interesting for policymakers. It's going to be much more interesting for journals in which you're going to publish. It's also going to be much more interesting for your employers. So, and it's going to be something that is going to keep you interested for the long haul. So there's some things to think about when you're looking at your research question. Can I have the next slide, please? Here, the thing about people who do research in corporate law or commercial areas is that they often feel quite challenged by theory. They are tempted to describe a situation and then to have a cut and paste reform. Well, that is not satisfactory. It is not going to get you published, and it's highly likely just not really going to add to the scholarship at all. So I would recommend that you look at these two simple theories that I think are really quite easily applicable to start with, to kickstart the way in which theoretical approaches it could apply to your research question. And these two really do apply to corporate research. The first is the TWAIL approach, which is, as you would know, third world approaches to international law. How TWAIL scholarship can give you a theoretical framework for your research. Now, TWAIL has been described as an attempt to understand history and structure of international law from the perspective of third world states. So it's basically saying that the development of international law is closely aligned to the colonial project. And it's saying that under the current economic order, which regulates us, corporations are a product of this colonial project. So corporations are furthering the ends of particular countries and particular interests. So in this way, international corporations function as a legacy of this historical origin. So the TWAIL approach could apply to corporations. And in just a couple of minutes, I'll take you through how you could apply it to different topics. But I would recommend that you do think about applying this third world approaches, especially when you're looking at issues such as the ability of holding corporations accountable and the jurisdictional, jurisdictional boundaries within which corporations operate. The second approach is regulatory theory and how it applies to corporations. This approach is taking us away from law being the way in which corporations are regulated. Regulatory theory is basically telling us that law is just one part of regulation. I suppose it has its origins in a lot of work that's been done by those regulatory scholars, and you can look at Braithwaite and Drahos's book in 2000 of global business regulation to kickstart your thinking. So these scholars are saying that law is just one part of regulation, and to effectively regulate corporations, one has to understand the networks in which a corporation operates and the kinds of forces to which a corporation responds. It's only by understanding that we can regulate them. So it's moving away from law and the state as a major regulator of corporations and looking at market regulation as a way of truly getting corporations to actually act in a reasonable manner and to be accountable. So these scholars are relying on behavioral economics, on psychology, and on organizational theory for formulating their principles. There's a whole lot of different ways they argue that corporations can be regulated, but basically they are moving away from the state as a regulator to non-state actors as regulators. And they're moving away from statutes as a regulatory tool to many other forms of regulation, which they call responsive regulation or restorative regulation, to try to persuade corporations, collaborate with corporations, and in some way nudge corporations to do what is required. So it's not a direct form of regulation, but it's indirect regulation where a number of stakeholders are called into this fray to regulate corporations. So I think regulatory theory is really essential if you're going to be thinking about reform proposals or analyzing the effectiveness of different kinds of regulatory attempts that have been made to try to regulate corporations. So they can apply historically and, of course, prospectively. Now, let me take you to the next slide, please. Let me now try to look at some specific topics just to think about how we can apply these theoretical frameworks and how we can formulate a research question and what kind of methodologies we could actually adopt if we're researching corporations. So, for example, you might want to look at the legal principles that actually apply to corporations, that on which corporations are founded. And those principles, as I say in that slide, are that it's a separate legal entity, that there's a separation of ownership and control, and that shareholders have a specific role and they're able to exercise this role effectively, and managers have a particular role and they too act in an appropriate manner, usually guided by fiduciary principles and contractual principles to make sure that the corporation acts in the interests of shareholders. So there's some legal principles on which corporations are formed, come about. They are the Law and Economics Scholarship, and if you wish to look at how persuasive it's been, the articles by Easterbrook and Fischel that talk about how effective and how efficient this type of separation of ownership and control and limited liability is in allocating resources is a very interesting, I suppose, a perspective that you have to really be familiar with to be able to understand why it has basically swept the legal imagination globally. So if you want to look at some of these principles, how can you go about bringing that particular topic? So what's a topic you're interested in? So you might be interested in shareholder engagement. That's what I said, because everyone's interested in how shareholders actually function. As long back as the 1930s, we were told that this whole idea of shareholders actually actively participating is a total myth, and they don't participate at all. In fact, all the participation is left to institutional shareholders. We understand that, but we still go on as if shareholders participate. So if you're looking at shareholder engagement, which we already know is questionable, you might have to narrow down that topic to a research question. So you might have to bring that down and ask about whether shareholder participation functions in different jurisdictions. So here I might take you to a student of mine who looked at a legal principle that is this corporate law principle of a statutory derivative action. A statutory derivative action came about in order to give shareholders greater powers. So it acknowledges that shareholders aren't being engaged. It acknowledges that it's impossible, sometimes impossible, often difficult for shareholders to bring about and control managers. So a statutory derivative action has been introduced in numerous jurisdictions to allow the minority of shareholders to be able to bring an action against the company when it's quite clear that the majority will not do it, either because of inaction, disinterest, or because they are being controlled by the managers themselves. So you might want to look at shareholder engagement. Therefore, you're looking particularly narrowing it down to statutory derivative action. Here you might want to formulate your research question, which is how effectively does the statutory derivative action function? And the student I had supervised, Hao Nguyen, did this and asked how it applied in Vietnam. The statutory derivative action in that instance had been transplanted to Vietnam, and it was considered to be a huge improvement of corporate regulation in Vietnam, and they expected great things. So the question that was being asked by Howe is, how effective is this going to be? How effective is it? He undertook, in that instance, some empirical work by talking to a couple of the regulators at the time and conducting some interviews, but they were qualitative and not quantitative. There was little quantitative data available because the statutory derivative action had never been used in Vietnam, even though it had been introduced for a number of years. So now let me take you through and look at what kind of theoretical perspective that he used. He used a couple of different perspectives. One of the perspectives was looking at transplantation of laws into other jurisdictions, here relying on the writings of Watson and relying on the writings of Taubner to try to look at how effective are laws when they're transplanted to another jurisdiction. One of the arguments that's put forth is that you can't actually expect a transplanted legal rule to work in the same way as it works in its original jurisdiction. It's been proposed that there are many factors, many contextual factors that reshapes the rule and may make it into something else that could be a legal irritant to that rule acting in the same way. In this particular thesis, Howe, looking at statutory derivative action and its application in Vietnam, found that there was all these different contextual issues involved. The first issue he found was that, in fact, most of the corporations had a huge holding, majority holding by the state, which meant that the government was a major holder, major shareholder, and the government was unlikely to be utilizing its power to bring a statutory derivative action. Nevertheless, it's still possible for a minority, exactly. The second point he came to was that the judiciary are actually appointed by the government and they are trained. So unlike a common law jurisdiction where lawyers are appointed to this position, the judiciary in this instance are civil servants who are promoted to a position of deciding cases involving corporate disputes. So the judiciary are actually civil servants. They're appointed by the government and they have got to fulfill a government mandate. So the second point he found was hesitancy by the judiciary to actually find against the state. The third aspect that he found in his thesis that was also contextually driven was that the idea of protest by shareholders was very new. Vietnam has has culturally polite norms where disputes are settled behind closed doors, and resorting to complaints in a public arena is not the norm, unlike India. So this kind of protest too was something that meant that utilizing the statutory derivative action by minority shareholders is going to be rare. So because of those three factors, the statutory derivative action rule that had been transplanted in Vietnam was going to fail at the outset, as it did. But this theoretical framework that he adopted of the legal irritants and the contextualizing of transplantation provided him with a really sound framework for further scrutiny and critique. The other theoretical frame that was also used in that thesis was the TWAIL, or the Third World Approaches to International Law. Here, he was able to examine the role of international organizations such as the World Bank and other international donor organizations, as well as multinational corporations who were very interested in promoting global governance. So they wanted the same rules available in all the jurisdictions in which they operated. So uniformity of rules meant less regulatory costs for the corporation. So the corporations were via the World Bank and the donor organizations, and they were also offering their own legal assistance to the policymakers and the regulatory bodies in Vietnam to help draft the laws, which was a cut and paste of Australian law. So it basically mirrored Australian law. So he was able to use the Twale scholarship to argue that the colonial project is still continuing, albeit through different means. In this instance, through donor money and through aid organizations and through multilateral bodies. So it provided a really solid way of exploring a specific legal rule, in this case, a statutory derivative action being the rule. The methodology, as I said, was empirical, but it was only part. The theoretical frameworks were the two, the transplantation and Twale. And the research question was narrowed down to exploring the effectiveness of a statutory derivative action in Vietnam. So he was able to bring it right down from swimming in the big wide ocean to a really solid question and an anchored one that he could answer. Can I have the next slide, please? Thank you. There are many other topics that we can talk about, but perhaps one of them here that I can talk about is regulating international corporations. As we know, global corporations are quite the norm these days, and it's global money, it's global capital, and it's global corporations. So the role of externalities, which is the climate-related damage that's caused in one jurisdiction, the environmental harm that's caused in one jurisdiction, is then left there, but it is nevertheless a problem that we face in this world, on this earth today. It is a problem that involves us all. When you're looking at this kind of thing, it is possible to go beyond the theoretical frameworks that I've mentioned before, which is basically the Twale and the transplantation and the regulatory theory, to also look at earth sciences and to adopt that as well, and to talk about a non-jurisdictional space being the world as one that we should be regulating rather than looking at a jurisdictional space of legal jurisdiction. But I'll leave that there. Here, in relation to this topic, I want to really look at how the regulatory theory as a theoretical framework can guide your research. As I said earlier, regulatory theory is based on the notion that we're not really looking at law anymore to regulate corporations, especially global corporations. We're looking at self-regulation by the corporations themselves. We're looking at codes of conduct in which is usually a collaborative process between governments and corporations and associations. And we're looking at codes of conduct that are also adopted by international bodies such as the OECD or the accounting bodies. So here, we are looking at regulatory theory, and we're looking at how beyond law we can regulate corporations. So let me here look at the example of a research question, which is how do you regulate for legal harm that's caused in one jurisdiction? And the example here we can go to is Nigeria, and the example of the damage done. So in that instance, we can look at regulatory theory. What kinds of activities, what kinds of responses are needed? So it's not just the legal responses, but it could be responses of censure by governments. It could be the responses by investors, such as superannuation funds, of putting their money into companies that cause this kind of damage. It could be actually altering the Alien Torts Act to make corporations who cause harm in another jurisdiction liable in the jurisdiction in which they actually are incorporated. So the idea here that I'm exploring is self-regulation and codes are not the only thing you can look at with regulatory theory. You can also look at nudges, you can look at other stakeholders and how they act, particularly superannuation funds that I know are becoming so involved with the way in which money is being invested. So the role of institutions such as BlackRock, which is now saying that they will no longer invest in companies that are responsible for climate risk, is something that's worth exploring, because those bodies are also shareholders. So their role, however, is unique, and being able to follow through the way in which they have been able to bring about corporate change will be fascinating. So what kinds of theoretical frameworks apply there? As I said, it will be the theoretical framework of regulatory theory, but you can also adopt this notion of TWAIL, of course, in trying to show that certain codes and certain self-regulatory measures are going to be unsatisfactory, because the corporation has always tried to be part of a different project, which is basically not to be controlled by the nation state in which it operates, which is the reason it participates within the development of its own codes. So it's possible to tease out that kind of theoretical perspective in analyzing the effectiveness of self-regulatory measures and to propose further kinds of measures that could apply. So that is looking at externalities, and is it possible at all to make corporations liable for the externalities that the idea of limited liability doesn't actually even think about. Can I have the next slide, please? I just briefly now wanted to touch on some other topics, which is another topic, as I said, is activism to bring about change in corporations. So here I am talking about institutional shareholders, but also consumers themselves and how they have been effective in trying to bring about change. I think it's quite a significant topic, which will use regulatory theory to talk about it, but also will use contextual and interdisciplinary approaches. The other topic that is quite interesting right now is this idea of modern slavery legislation. So what this is proposing is it's trying to get national governments to now pass laws to try to make global corporations liable for their activities outside the jurisdiction. So governments are reacting to the kinds of externalities, not just environmental, but also to human rights abuses that happen in other jurisdictions, and are actually passing legislation in their own jurisdictions to make global corporations accountable. When you're looking at such a topic, you can again go back to quantitative analysis and qualitative analysis, because it involves looking at their annual reports and disclosure documents. You can also use those disclosure documents to assess the whole notion of disclosure as a regulatory tool and try to then bring about and use the other measures in the regulatory toolkit as potentially useful in making this particular disclosure more effective. So you could also, in that instance, use the Twale scholarship and try to argue that once again, corporations are running their own game as they always did. And the way in which the Modern Slavery Act is trying to regulate them is doing something new. It is trying to bring about a new paradigm, but you can ask whether it is actually being adversarial enough or hard enough on corporations. It's simply asking for reporting by corporations. So in that way, it's adopting a softly approach of collaborating and asking corporations to disclose, and whether that's effective in regulating corporations to create the kind of markets, global markets, that are going to make a sustainable planet for us. So I hope I'm going to stop now because I have spoken beyond the time that I was allocated. But I hope that you can see some of the ways in which you can research corporations. And also I hope that I have been able to communicate some of the ways in which I feel passionate about being able to research corporations, which is the main game in the world today. So thank you so much for your attention. And back to you, Amita.
Okay, thank you so much, Vijaya. I don't know why my camera is refusing to turn on, but I just wanted to the process that we often follow, and especially because I think it was such a rich presentation, and again demonstrated, at least to me, that when you are wanting to be working in any field, to think that, very often corporate law, people working in there are seen to be these, people driven by, even the researchers are seen as driven by profit motives of some kind. And so the way in which corporations have become like the concentrations of economic power, and the manner in which they are what should I say, controlling political realities, I think it came out so very sharply in the presentation you were making. And the fact that people who are, say, concerned with questions of human rights, questions of environment, are concerned about the way, the direction in which the earth is headed or the world is headed, could be sort of like working in the realm of corporations. I think that for me came in very dramatically. And also, I suppose, for us as law people, to be made aware of the fact that the moment you start to speak in terms of externalities, you are not just typically only looking at legislations and what the judiciary is doing or what designated regulators are doing, but also, like, when you are being, all of us are being now pushed into going into the market to be sort of like, I've just kind of superannuated, and I'm sort of worried into where should I be investing the money that I have got, as my terminal benefits, because fixed deposits and the safer kinds of foras are not really available. And if you are being pushed into the market, then it becomes extremely important for you to know, all right, which is the kind of company in which I want to invest, what shares or what mutual funds also I want to go for or not go for. So the point you made about superannuation funds and, like how people then decide which kind of corporation you want, and to like closely study that and see that as a way of researching corporations, and to look at the whole phenomena of regulation outside the phenomena of just what should I say, the typical traditional ways in which we look at regulation. Okay, these are the designated authorities who are meant to do something. But the fact that this, the very Foucauldian notion of power, that, it actually subsists with very many more other systems, it's a question of us examining that closely. So I mean, I found your presentation, like expected, really riveting. And also, like, I think, I mean, we give a little time to the participants to also think about. But I felt also the fact that you were asking for people to be, like studying disclosure documents, to be seeing what the financial statements are like, is to look at materials. You're still in some ways very much doing doctrinal work, but the kind of materials that you're examining are not what you typically see. I mean, these are disclosures made, to what should I say, legally constituted authorities, but we are not really looking at those materials in trying to then see, okay, how effective or otherwise has our policy been. Uh, I think amongst the things that we've been saying, and quite a many of people who have been coming on a repeat basis to various workshops, is that interdisciplinarity needs to be understood in a, like in a more imaginative manner. And one needs to sort of literally tease out what kinds of perspectives could possibly be helping us in provide reaching that research question, and what sort of theoretical assistance will help us in bringing the requisite layers into that question. I really want to very, very sincerely thank you, because in the sense of you're providing very concrete examples on how this can be done. The general process that we follow, I mean, of course, Vasanti, I could invite you that if you have thoughts that you want to share with the participants as well as others on, before we kind of give both Vijaya and the participants a small break, and then come back to sort of seeing what questions we want to, what questions they want to ask Vijaya, or what comments or clarifications they wish to seek.
Yes, I would like to join Professor Dhanda in, thanking you for an absolutely excellent presentation. Seriously, I had this kind of a hunch that there is definitely, I'm not a corporate law person. I had a hunch that, of course, there is more to research in corporate law. And for example, I teach a course on holding transnational corporations liable. And so I've been kind of exploring that kind of reading. So to hear it from you in that sense, that there are these various interfaces with the other branches of law, this whole business of how are we going to regulate? What is this new idea of a transnational law, and how it is an important part of corporate law research? It was wonderful to hear all of that coming from you, and I loved the examples that you gave, so that this is just not a project only in thinking aloud, but this is actually research that is happening. So thank you for all those examples. I don't think the PPT really captures the various points that you're making. So I'm so happy we've recorded this, because really it's been a session that people would want to listen to in bits and pieces to process it further. It's going to be very difficult for people to actually take it all in, because you've set such a wide canvas. And for a lot of students who are not exposed to this idea that corporate law can mean so much more than what they are ordinarily taught to think in such narrow ways, I'm sure everybody will take some time to process this and think about their own research interests and how they want to propose a research. But it's been an act, and to come at this point in our series, I mean, we've been right from the beginning. You're very right in saying right from the beginning, we've been talking about the need for interdisciplinarity, the need to be able to look beyond, read wider. So it was very nice and very heartening in the second set of workshops to hear you come back and say that, yes, don't just read what is understood as core corporate law. That doesn't give you a sense of the field, doesn't give you a sense of the impact of corporate law on our everyday life. So it was a wonderful session. So I think we should give students some time to process this. also give Vijaya like a 5-minute breather.
Grab a cup of tea or something.
And then you can come back and
Yeah.
Okay. Thank you. Thank you very much for your kind comments. And okay, I'll have a break now. Thank you.
we'll come back in 10 minutes.
Okay. Thank you very much.
So participants, please put down your questions in the chat box here, and we will come back in 10 minutes and take them. So they don't have to be like questions. They can just be thoughts, ideas that you're thinking about, possible directions for research, or general comments on the presentation.
Of course, we do talk on voice, but I was finding it very uncomfortable. I can't see.
I was wondering, why did you suddenly leave?
No, I mean, see what of course, as we are all pondering, I think what one really needs to look at in this session is this whole question of like from area to topic to question. We've been talking about this trajectory again and again, but what Vijaya has done is that she's provided us with concrete examples on how this can be happening. Simultaneously, the way she's used both regulatory theory, TWAIL, as well as, when she was talking about earth studies, or she was talking about, the whole issue of transplanting. I think these are the things that one needs to seize upon and think further. Whether or not you're researching in corporations, but the fact that she has provided those concrete examples here on how exactly that trajectory has to flow is something which is, I think, is of value to all of us. I just wanted to ask you, and I have been processing your presentation, and I was just, would it be correct that if today all of us who are looking or engaging with the whole issue of or looking at corporations need to be sort of seeing them as the new political sovereigns, or the sort of people who are going to be influencing political policy in a much greater way? You can't. I take your connection that you made with the East India Company, and you also spoke in terms of the manner in which corporations had played these significant political roles even when they were first established. But can you be saying that has very dramatically, or let's say a kind of a revisit is happening, especially for transnational and multinational corporations, that the sort of hold that they have on political policy or what is happening in various countries? You can't think about corporate law as an area of like just economic transactions. It's like the sort of way in which, it's like, like there was a point at which one started to say that everybody has to learn international law. So my question to you somewhere is almost like this, and after listening to you today, at least for me, it's been this huge eye-opener that you can't really say you want to do human rights, or you can't really say you're interested in democracy or interested in people's participation and not know corporate law, or not engage with the phenomena of corporations and how they operate and what kind of hold they have. At least that's for me, my big takeaway from your presentation. And also, see, Vasanthi, the conversation we were having around the whole question of labor yesterday, the right to work and stuff like that. You see how this intersects in such a major way. So I thought it might be a good place to begin from, because amongst the things that happens for a lot of people who do, say, public law, they will say, I don't do corporate law, or I don't really look at corporations. I don't know what the whole regulatory theory in relation to them is. Do you think that's a luxury any one of us can afford today? If we say we are serious about, say, even human rights or environment or labor rights, can we really be doing any one of them if we are not researching or reading, if not researching, reading and engaging with questions of corporations? The reason I'm asking you this question, like I said, that the relevance of what you're doing here is kind of straddles across other areas, and your example of international corporations brought that in again, and also the connections you made with both the technique of transplantation is not used only in relation to corporations, it's used several other places. But I still would want you to first respond to that big question I'm asking, because I honestly felt after listening to you that, how can I not be reading disclosure statements or not see what a company's, investment policy is like? What does it spend money on? How does it conduct its own affairs? Not just like, the thing that we talked in terms of the equal opportunity employer and you getting yourself that, those, the badges of being a good corporation, the so could you just respond or react?
Yeah. Thank you.
If I can just tag a small questions, it's what Professor Hannah already asked, but I would want like a yes or no answer to this. So I have colleagues who would say you can't teach corporate law within public law because corporate law is private law. So this whole business of how do we classify corporate law?
Yeah. Okay. So just as I thank you for that. I think just as a movement, the notion of governance, as we have already said, has been fading for so long. This idea of the neoliberal economy has been with us for decades now. And we often talk about Margaret Thatcher and so forth, but it's been there for long before that. And the idea is for the state to become more efficient in doing what it's doing, which is to just do defense and migration, and take political donations and let everything else go to corporations. Some countries have been able to halt that process and it hasn't been as effective. But in answer to your question, the role of corporations has been growing significantly forever. And the old deregulatory movement has been a voluntary handing over of power in the developed countries, using the economic rhetoric of market being the efficient allocator of resources to corporations. So even the government's job of social security provision is handed over to corporations. Even the government's job of poverty alleviation and providing homeless people some shelter is now being handed over by governments to corporations by allocating money to them to do their work. The idea clearly is partly because of efficiency and all that stuff they talk about, but also partly because of distancing yourself from a provider role, which then you can obviously, you're not an expert in provision and so forth. So the role of the state has been shrinking forever, and it's so evident now with security forces that are being supplied by corporations. So it's no longer just the food we eat, it's the security that we have is corporations. Everything has been handed over to corporations. So as far as, and it's a real tussle when you see, when you have to beg Google to shut down and Facebook to shut down clearly fake news and so forth. It's not a demand that governments can make of corporations anymore. It's a process of negotiating, going softly and begging. And this is in the countries where the corporations reside. So we're talking about the United States, we're talking about Australia, we're talking about India, we're talking about the UK, France, in these countries. But if you talk about the less developed countries, which are the sources of raw materials and labor, it's just the same old story of the colonial project, as we talked about before, where there is an alignment in the way they actually assist the state perform their job. So they're assisting the state with legal assistance. They're assisting the state with heaps of donations. They're assisting the state with provision of home, of health, of all kinds of things. So they are running often, as you say, they have taken over the provision there of everything, of really running the government in many of these countries. And the ability of some of these companies to be able to then sell, so, and the example I will use here is PNG. The ability of these companies, where I do some work for a couple of development organizations, the ability of these mining companies to just actually form alliances with governments to get mining licenses and so forth, and where there is a disaster, to pack up, to sell to existing shareholders within the country for $1. And we all have heard this story before in India, in everywhere. And they have gone out of the country and they are not actually in any way held responsible. So these stories of a corporation actually running countries, of becoming the sovereign in so many ways, is really, it just cannot be forgotten. The role they play in political donations and political influence is something that's been looked at before, and that's something that motivates a whole lot of legal reform and so forth. With labor law, there's been quite a big debate here going on about seasonal workers program and the workers that corporations can bring out to assist them perform and who they would prefer. And they're always given preference. So, the kinds of labor that's required by corporations is given preference. So, and they're the ones that now decide so many things about, with the Modern Slavery Act, it's all about reporting what kinds of child labor or human rights abuses or the conditions in which people are working in Bangladesh. They have to report that to the consumers of Topshop or Zara or whatever it is. So those organizations are actually expected to report. So the story, as you say, is, as a citizen, if you don't look at those reports, as a consumer, if you don't consider those reports and check the adequacy, then there is absolutely no regulation happening. Because the whole idea of this market regulation and disclosure is for these corporations to actually look at what they're doing in other jurisdictions and report. Well, who are they reporting to? They're reporting to the ultimate consumer and the shareholders. So as shareholders and as consumers, as citizens, we are being asked to hold them accountable. And we can vote at these meetings. We can ring up our superannuation fund and ask them to pull it. And now there are many middle organizations that are coming up, activist organizations that are coming up, such as a Responsible Investment Association that reports on how banks, which are corporations, are lending money to corporations which are causing human rights abuses. So they are reporting on the lending process by banks. So the scrutiny then is on banks that are lending money to a mine that's actually caused a disaster, or to a particular pollution that's occurred in the seas. So the actual responsibility comes back to another corporation, which is the financier. So we're holding the financiers liable. The financiers also should be taking some responsibility about where the money goes. So in this way, every citizen has a duty to pay attention. the difference between public law, Vasanthi, and private law is, I think, is a good question you ask. And my answer to that is corporations are actually performing more public duties now than the government's performing. So this distinction to me is irrelevant. This distinction that we can actually scrutinize governments for the way they operate, and all they're really doing is handing over money to corporations to do the work, but not scrutinize corporations, to me, is really quite strange. So these large corporations are bigger than governments, and they're bigger than many of the governments in which they actually work. Shell is a lot bigger than Nigeria, than the Nigerian government. So holding these old laws that are meant for a different time and were served a different purpose, maybe the purpose is the same, I don't know, but using the same laws is irrelevant now. So I do believe that relying on legislation alone is just, it's actually, it is not just ridiculous, it's not done by anyone else. Corporations don't rely on legislation. Corporations, any corporate lawyer will tell you that the last thing they really care about is actually breaching a law. What they really care about is that they will stop getting their flow of capital. What they really care about is they'll really annoy institutional shareholders. What they care about is that there might be some awful publicity that might mean that their goods get off the shelves. So what they care about is terrorism, citizens terrorists who might go, as they have in Australia, and put a few needles in strawberries, which killed the strawberry market for a considerable period of time. That's the kind of thing they care about. And they care, of course, about their databases and their own privacy, and they want to keep their information close. But they don't really worry about law. So when we teach law to students, and we teach corporate law, we're not preparing them for what they're going to have to do. We're not preparing them for the kinds of policy documents and public disclosure documents that they're going to be actively preparing to put on websites, because that's what is the interface between the corporation and the public. And that is actually, in some ways, a document that can contain misleading conduct, that can contain promises, that can contain all kinds of, possibilities for legal action. So all of those things should be taken into account. So in answer to your question, the way we teach corporate law is really a 19th century concept that again and again and again has been shown to actually be a fantasy. First, they tell us that the shareholders have some say. Then they tell us in the 1930s they didn't have any say and we're going to introduce special procedures. Then they tell us that these special procedures don't work because really the institutional shareholders have a lot more. So slowly and steadily, they are telling us that the actual way in which corporations are constructed belongs to mythology. But we're still hanging on to it and teaching it every day as if a shareholder, me as a shareholder, has the same rights as, a shareholder, which is my superannuation fund. As if me, who votes for my one share, actually acts in the same way as a superannuation fund who picks up the phone or has a drink with the director of the company or goes and, basically says, listen here, and spells out what they need. The forms of communication, voting process, totally irrelevant most of the time. Proxies is irrelevant most of the time. And we're still teaching people how to vote at a meeting instead of teaching them who are the real stakeholders in actually getting corporations to do what they're doing, and in teaching them that partnerships have to be formed if you're going to regulate corporations, both if you're working in a corporation and if you're working for a citizens or an NGO who's trying to regulate corporations. Either way, you have to be aware that it's a much more fluid situation of networks of alliances and of speaking each other's language and respecting it. That's just a way of
absolutely. I mean, I was also thinking, in Indian case law, I mean, it's an old case of uh, Justice Matthew of the Supreme Court in the case of Sukhdev versus Bhagatram. I mean, it's a concurrent judgment. I'm only sort of sharing this with you, Vijaya, because it's a decision which came in around the 80s or early 90s kind of a decision. And he spoke in terms of, because the Indian constitution makes only the state responsible for both the upholding of fundamental rights, as well as if there is a breach of fundamental rights, you as a citizen or as a person have any kind of recourse to remedy if the infringement has been done by the state. So a large amount of Indian constitutional law revolves around the fact of whether the authority against whom you are complaining is quote unquote state or not. And the manner in which state has been defined in the constitution, there is a particular phrase used as, like other authorities. And that other authorities has been expanded by the Supreme Court over a period of time. By the Supreme Court, I'm saying Supreme Court because like that, their rulings are like law of land sort of thing. So they've expanded over a period of time to bring in more and more entities into it. And you've had a body of case law which is around whether corporations can be held liable for infringement of fundamental rights or not. And in this concurring judgment, Matthew had formulated this phrase of what he spoke about as concentrations of economic power. And he said these concentrations of economic power, the sort of hold they have to be treated and thought of as state. He was doing it as, because he was one of those juristic activists, in the sense he would put ideas into his judgments which were about the direction that you should go into in the future, not necessarily come to a decision which will say that, no, I am holding such and such corporation to be state. He wasn't doing that, but he did kind of, and then subsequently when we had, as a precursor to the Union Carbide decision, you had the Shriram Chemicals decision, wherein the Supreme Court came up with this formulation that when it comes to the right to life and liberty, whether or not an entity is state, it doesn't matter. If you are in any way doing any action which is breaching people's life and liberty, you are committing what they call the constitutional tort, and hence can be held liable through that route. I'm sort of like just saying that all of these developments actually point to exactly the fact that this happened in Indian law. Yet for us to be like, for our corporate law teachers and for others, for other people who work in the field to claim that this is not an area of public law, or this doesn't have an impact on the quality of life that you have within a country, is in some ways, I would say, preposterous, but it kind of still continues to happen. Maybe it's a jurisdiction issue of another kind, an academic jurisdiction. You feel that, oh, this is my field, and you can't trench into it and bring in areas and issues which are of maybe of interest to you, but in some way it diminishes my specialization, and hence I'm not. And I think it's important that we should be having this conversation in a Flying Research Guides workshop, because it is to tell people that, listen, the territory itself has been not very correctly, the boundaries have not been correctly drawn for you. You need to redraw those boundaries to work out exactly what you should be researching on. Last week, Vasanthi was making a presentation on reframing labor law. And my first question to her was that, do you think you can really reframe labor law research if we don't reframe labor law teaching? If we continue to teach people through legislations and, make it like that the legislation is in fact dictating the life of the law, when it's not. like what is happening to labor or work on the ground and what is provided for in the legislations have nothing to do with each other. I would some way say similarly, like what the Companies Act or other statutes, which are various regulatory statutes, ask companies to do or not do, is not actually how corporations are functioning. I mean, that's a point you're making.
I agree.
But when we teach corporate law, we don't do that. And you'd have, I'll have colleagues who would be sort of tearing hair and saying, I have 500 sections of that statute to teach, and you want me to teach it in one semester. Whereas if they were to kind of, see the larger forces and work there and then see, okay, what role, if any, does legislation play? The conversation reaches a very different kind of conversation starts to happen. It's almost like,
You're right.
Vasavi, I almost feel that, we just don't do a labor law thing. We also see what we should be doing in corporate law.
Corporate law.
Yeah,
No, the difficulty is not just that they have 500 sections of corporate law to teach, but the complete, denial that there is even an angle of public law to corporate law, and to kind of construct it as, a kind of a monolith which has no, no interface with public law, is where, I really struggle with colleagues and try to get them to see that, this is huge change. And I really liked your idea of a myth. So maybe the next time I meet them, I will tell them, what about this idea that you're teaching it, at a time and a place, and from a time and place which is no relevance anymore. But in terms of
maybe we should make their version of as part of law and literature. Because we're teaching mythology.
Mythology.
Okay,
Mythology would be better, not just literature. We start a course in law and mythology, and we teach that corporate law, and we need to see how that will work. No, but reformulating and even reframing the field of labor laws. I mean, labor law also, in that sense, I would want to draw an analogy by saying that the way in which we usually teach labor law is also in this mythological mode, where you're saying that there is an industry which is confined in this place, and there is a factory, and then there is an establishment, and that's where work happens. When all of those ideas have become so outdated and irrelevant, and we continue to teach labor law like that. So there was this interesting idea of where perhaps labor law and corporate law can come together, and to teach it as a law of economic subordination. I was wondering if you would have any thoughts on that.
Yeah, I think that's an interesting idea, because I think that's an interesting idea because labor and the way in which labor is treated so depends on the corporation and and each corporation, as we know, has its own supposed relationship with its employees, its own ethos. So we all know that Apple supposedly, they all wear sneakers and play table tennis, and it supposedly has this when and we know different organizations supposedly have this culture. When I completely applaud that idea, but I was thinking as you were speaking about this the point you had made before with the Supreme Court judgment, Amita and Vasanthi, the siloing of all these topics that we do, is competition law. The very premise of competition law is that corporations come together to cause harm. So we've got to stop corporate concentration because they'll do something bad. So we've got to make sure we watch them really carefully that they don't do something bad. So the premise is corporations will get up to mischief if we let them all form a cartel, or if we concentrate, they form a cartel, and soon they'll become a monopoly and they'll wreck everything. So there's a real suspicion of corporations in competition law. And then they draw these rules for how you have to deal with it. But in corporate law, there's no suspicion at all. It's all based on, everyone is giving out information that's relevant, and there are these meetings and everything is going splendidly. It's quite interesting that they're completely different premises on each one. So the Supreme Court judgment you were talking about seems to belong to the former, where you have got to scrutinize the power of any entity. And the more the power, the more the possibility of mischief. And that isn't translated to transnational corporations, except if it's this vertical and horizontal thing that comes within competition policy of market power, which they can easily avoid because, they can just do it in a slightly different way. So and also corporations are so clever. They are way, way, way ahead of all of us. They have hundreds of us in each department thinking how to be cleverer. So they don't actually purchase. So a soft drink company knows that by buying the other biggest soft drink company in the market, it might breach the laws. But what it is doing now is buying diet companies, because it knows that an outcome of soft drink consumption is going to be obesity. So it's buying diet companies, which is not in the same market, so it's not regulated. So they can buy all the diet companies they want. And it's quite common for them to go into related markets. So all the smoking companies are now buying all the related products. I mean, surely they'll all go into health soon, but they're also going to slimming, the soft drink companies, the dieting company. So the way they think is always to avoid these siloed ways we consider law, rather than thinking about it as you called it, as what did you call it? The actual, was it the oppression of, no, the
subordination, economic
subordination, the subordination of, or the facilitation of. So they don't think of it that way, we don't think of it that way, but that's how they think of it. So we are running behind trying to regulate something using completely different tools, but they are thinking of it in a different way and acting differently. So, I mean, this is a problem in regulating corporations. So nobody knows how to regulate corporations because of the electronic transactions. They don't know how to actually go in there and figure out how they actually decide the price at a particular day, because they don't know the algorithms they use. They can't figure it out. They can't get on top of it. So they don't know how to regulate it. So what do we do in the end? We ask them to regulate themselves, because we're not able to regulate them. So we ask them to regulate themselves. So the biggest regulation is supposed to be, as we all know, that UN guiding principles for business and human rights. We don't know how to govern them because we're fighting with our neighboring state where all the human rights abuses are going. And we don't really care if they're human rights abuses in the neighboring state, as long as it's not in ours. And they don't care in the same way. So we're relying on corporations to regulate their own breaches. So, sorry, it's just to say the way we silo our laws, and we have the different departments that don't talk to each other, and scholarships and lecturers and academics who don't, and publication in journals that don't tread on each other's turf. But it's exactly what they already know. And unless we can actually bring down some of those, even in the way we research, we're not going to be playing the same, we're not going to be in the same ballpark. So that's a longish answer to what the points you already made. But imagine relying on corporations to govern themselves through UN facilities of disclosure. How effective is that going to be? Maybe it is effective.
It's a very potent area of research, all right. And I'm sort of like starting, maybe because one is, I'm revisiting my acquaintance with doing full-time research, and I'm still kind of shaking off my teaching mantle, that I keep making these connections and saying that how are people going to come and do research in this kind of areas if their understanding of that area itself has been strangleholded and disciplined in a particular way? So to break them out of that discipline, it's an important activity that has to be undertaken, because if they are coming to do research in this area and are not, especially because academics are not the ones who have gone and say maybe worked in a corporate firm and seen an exposure. Very many would have a student who's done, say, an undergrad degree, then done a master's, and then is now coming to do a PhD in corporate law and has not had this kind of market exposure. So their understanding of the discipline is what we give them at the undergrad level and then build it further at the postgrad level. And this kind of critical insight is not a part of it. And yet it is amongst the greatest in demand kind of specialization. And let's if we are real about it, I'm certain that if we were trying to do, say, a course in economic exploitation or something like that, you will have no takers. And you'd have almost like the university being told that what the hell are you up to? Because we are supposed to produce these meek lawyers, people who would go there and do those due diligences and work out the sort of things which gives the facade of that you are. But the hard questions, how we have to package and talk about it, definitely whatever else we can do, we can't call it law of economic exploitation. It will
No.
It will fail.
No.
I mean, you have to give it a sexier title and you have to think about it differently. I get the point that Vasanthi is making, but I do think that the reality of getting courses to fly is also a very, I've taught for 20 odd years a course in law and poverty. And the reason why the course carried on is because we insisted that it will be a mandatory course. We're not making optional to students that they can choose to be in it or not be in it. And then whatever brainwashing we wanted to do or conversations we wanted to have or not have. I'm sort of saying it. Corporate law is also like a mandatory course for us. But I think the candidates may, or the students, the people, the registrants might have questions of their own. We've just decided to take you over. I think partly Vasanthi and I have been having this conversation around how to rework labor law. And suddenly, as I'm listening to you, I find that the way in which we teach corporate law, these kind of critical questions don't emerge from that kind of teaching. You require a very different body of education or exposure or readings.
The point that Professor Vijaya was making, which I really liked, was that people are actually doing it. See, when we say that we're supposed to be producing meek lawyers, there are obviously very sharp lawyers out there who have already done this and, who don't operate in silos and who know exactly where things are hurting them. And we're not asking our students to think like that, but there are people who are thinking like that, and there is a demand for people to think like that.
Yeah, but Vasanthi, primarily from lawyers who join firms, and then as a demand of what that firm is requiring you to do, you're learning it, which is very different from the sort of stuff that we are talking about. I started my conversation with Vijaya by saying,
I think it might be worthwhile.
If I see myself as a human rights person, pardon.
So I was thinking it might actually be worthwhile if we pursue an elective course by teaching them, even if teaching them this is what corporations are actually doing, and that there is this entire formulation of policy and regulation within corporations, which is beyond what you're ordinarily taught in corporate law. And I think we should be able to create a demand there. I haven't given up on that idea yet.
I think textual analysis.
I'm not talking about giving up. I'm talking in terms of strategizing. I think we'll also maybe the candidates or the registrants would have questions of their own. Otherwise, Vasanthi and I are quite happy to just talk with Vijaya. But because you hadn't typed in anything, I thought that maybe our conversation might trigger concerns for you. So we give you your opportunity. At least you shouldn't say later you all didn't even ask us. Sana, Kumar Raj, Vetha.
I might just speak up and just say that one of the ways to encourage people, I think, to think differently is to actually get into some documentation of a corporation. So a simple way in which you can encourage people is just look at their environmental and social disclosure in their annual report, just as a way of seeing how they have changed over the years and to assess that in real time to see whether that is actually what's happening. So it is a small way of teaching critical skills to actually look at those documents. And it's also teaching how to look at corporate documents. The other thing I found really useful teaching corporate law is, I'm sure India is so vastly advanced, is we have online and televised general meetings of companies. So to actually play some of the general meetings of companies and shareholder protests that happens in meetings and how they are dealt with as part of a lecture is actually quite a good way to get students to see the power distribution, the shareholder differentials, and the participatory barriers that exist. And the other thing I have found really useful is actually to bring up some of those protest organizations and include some of their literature as a way of as comparing what the company actually says and where it goes. So it's just actually getting to read some of the company documents, which you can consider to be a technical skill. You are encouraging students to follow, and there could be no objection in that. And it's trying to teach them that law is not the only thing which corporations look at, because they're all using behavioral and psychology anyway, even in appointments. So to look at so to apply regulatory theory rather than just doctrinal analysis, and to look not just at fines and license revocation, but to look at consumer bans and politicians' censures or politicians' praise of companies as also a way of trying to enter into that regulatory fray. So that's a way of just getting students at the very basic level to think about corporate law as being much wider than that. Or even a case study of how a corporation reacts to a disaster. Does it look at law, or does it look at consumers, its shareholders, its overseas partners? Who does it look at first? So looking at it from the corporation's perspective of where does it place law is quite a good way to interest students in reality and also use available documents that's well within the syllabus and well within an academic's law lecturer's mandate to basically push the envelope a bit. I would recommend, I would suggest.
I think it makes a lot of sense in sense of like, as a person who was teaching legal theory for long, I used to teach a course which I called applied jurisprudence. And I felt that you talk in terms of theoretical perspectives and you don't situate them into real life situations and how people make their decisions on. The theory seems too far for the student to be of any real utility, Whereas if that same theory assists them to understand the life around them, they start to see that, yes, it equips them with something which is, which gives a kind of a cutting edge, which is what a lot of them are looking for. On a similar basis, I would say that if you say that, we're going to do something like doing corporate law or, understanding corporations, you call it something of that kind, and then say that you need to be learning how to, what the course is going to teach you or what you're going to research there, because then you could push people to sort of look at these connections in a sharper way, sort of things. Understanding corporations and saying, okay, fine, let's see how they understand the whole issue of whether it's responsibility to shareholders or responsibility to the larger society. What is a contribution in relation to the environment, in relation to creating a safe working space? You work out those. I mean, these are parts of your regulations, and you're trying to comprehend it. And that fact that we can actually try to comprehend it from not any other place, but from what the corporation itself says about it.
And I think
See,
also
nobody can then accuse you of the fact that, you think this is what you are saying that you are doing, and these are the other kinds of, and try to see that mismatch. Or also like the kinds of things where they're evidently faffing, they're saying things which they're evidently not doing, but we never look at what they are disclosing, so you don't know that, okay, if this is just a formality, see, there's a certain cynicism which will be put out there, and you say, anyway, they're not going to follow it. But to do a documented study of the fact of how they have not followed it, and yet they are filing these documents, which they are legally required to do, and these are the breaches you found there, I think it could be amazing. I mean, I'm hoping that people who want to be doing research in corporate law, this is doable. It's not, like most of the time what happens, Vijaya, is that any kind of work which requires, especially for law people, to go into the field or to do what they call as empirical research, gets people, to step back. We are having this very real situation in India today, is that whilst a doctorate has become in a mandatory requirement to do an entry-level position in the academy, like if you want to first an assistant professor, you're insisting that you need to have a doctorate. Even a master's is no longer enough. We had a master's, and then we also had a kind of the University Grants Commission was requiring people to do a national eligibility test. So you needed to pass that test to be able to get the entry-level requirement. Now they are saying that no, everybody needs to have a doctorate. So you're literally pushing people into doing research while they're not even ready for it as yet. They need that time between doing their postgrad and, like acquiring some life experience and then coming to do research. In that kind of a scenario, I feel that if we don't have hard conversations which equip people to sort of understand exactly how they are to situate themselves, we're going to have, it's not going to encourage research, it's actually going to depress it. It's not going to bring quality research. What it's going to do is this, that you're going to have just any, like people are going to check the box, and because we also simultaneously have another regulation, condition, which is saying nobody can become a professor unless you have successfully guided a doctoral research. So all you need is the two to be in complicit with each other, and you can have doctorates coming and you can have professors, and neither is going to gain from the whole process. And it's like, you say it like that and it's evident that it's a bad idea. But I know the motivation behind both is this, that no, you cannot be a professor if you haven't learned to work for a, okay, fine, you get that thank you note from your candidate. But in the main, it is like large amount of work that you're doing in the background to get someone else to be able to become an independent scholar. That's basically what you're doing. And so you're saying that, okay, to be a professor, you have to be self-regulatory. So you should be demonstrating that you're capable of doing work, irrespective of what it gets for you or not. But if you do it in this kind of connection, then it creates other sort of difficulties. I'm raising this because somewhere this, it's a very real crisis that one is faced up with. And it's demonstrating is that where you're bringing regulation is in effect an attempt to sort of like raise the standards of the academy, but the regulation is going to have a totally counter effect, because it's just not understanding the reality of youngsters who've just finished their masters, who want to, like, because as it is, law study takes longer than others. Then on top of it, if you're going to bring in these kind of regulations, you create other difficulties. And I at least feel that it's important that when we start to regulate other people, we also look at the impact of regulation on ourselves, and say that if this is what the regulation is requiring me to do and it's not possible for me to do it, I am going to find, jugards, like we say in India, of, ways of getting around that rule. I'm not going to really follow it in either letter or spirit, or follow it in letter, but definitely not in spirit.
And that
So we
won't
have
do
this
anyone any good.
Hmm?
And that won't do anyone
Pardon?
any good, neither the
Yes, it
academy,
won't do
the
anyone
student,
any good.
or
True.
the
That's
professor.
exactly the point. Absolutely. And the other thing, somewhere, Vijaya, is also this, is that I suppose this is a larger conversation we need to be having. And is that when we talk about law in this very passive way of this is what has been provided and hence this is what I am teaching, and we don't keep asking, but should it have been provided in this manner? As a citizen, as a student, as a person who's, it's important that that insight is a simultaneous process. I know we can't change that law, but if we don't ask that other question, we kind of reinforce all kinds of stuff, irrespective of whether it should be there or not. And I think that for me is the bigger challenge of legal education, that if it's not teaching the student to ask the why question, then it's not really performing. And I think possibly, and I'm saying this to, even if you all are choosing to stay silent, I don't know whether I'm not shut up enough for you to give you a chance, but I actually think that when you do a doctoral piece of work, and I'm saying it in virtually every workshop, this is your, calling card to being an independent scholar. So how you do it is that you should, at the end of it, feel equipped that yes, you are an independent scholar. If and it's still, what should I say, burdened by whatever your supervisors or your other life difficulties are causing you to do, then you might get your doctorate, but you can't say that you've, really got that calling card. And I think it's important that we understand that as we make our choices. None of us can regulate to this extent. If somebody doesn't want to go take the bylane, they will. You can't do. So I'm asking you all a last time, taking over Vasanti's duties. Does anyone have any questions from to Vijaya, or as such want to contribute to this conversation that we've decided to have?
Good afternoon, ma'am. Since
Yeah,
this was a freewheeling conversation, I thought I might ask a tangential question, if that is okay.
sure, please.
So, like even the previous session and this session, we've been talking about pedagogically how you should uh, design a course and all of those things. And one level of anxiety which I've been having is, once you design a course, you definitely have the secondary part, which is evaluating a course. So I was wondering, what should be the objective of evaluation? What, like, once you are teaching students to ask the why question, uh, then your examination can't be like, tell me what section 2 is, or apply this to that. So what is the object, what should be ideally be the objective of an examination, and how should one think about how to evaluate the answers in some manner?
I think that examinations perform a particular function. And I don't know how much time examinations, particularly if they're timed, within the 2-hour zone and so forth, give room for reflection. So I'm not sure about whether you have alternative forms of assessment in Nalsar, but certainly I find that think pieces which involve some reflection and involve a bit more critique and also demonstrate wider reading is usually in the form of essays or blogs, where you can do it without being timed. Even having a simple document where you can comment as a blog or comment to other people's comments and encourage the discussion to go on is, I think, a way of evaluating this. Exam mightn't be the best way to evaluate, because exams are so much focused on problem solving, on sections, on yes and no, depending on how you frame it. So I would imagine that having a blog where people participate over a course of 3 or 4 days, with ideas, with ways to reconceive it and what that might mean, will enable both learning from others and also will force participation, which is what actually students should be learning at universities. And that's what they find quite difficult when they haven't done it in business, which is to speak up and to push themselves forward with a view. So I think it has a number of educational benefits to use those alternative forms, such as an essay or a reflective piece or a blog, even though the marking of it could be minimal, as in, you allocate a certain number of set marks. It's a process of some reflexivity. Amita, what do you think?
Yeah, I would say something similar. It's like, it's not just, in fact, even in a closed book on-site exam, you could literally be asking just one question and asking them to think about it over a period of three hours or so. It's like, it has this one advantage that the student has to give just defined time to the whole evaluation process, whereas the blogs or the take homes and the others require them to invest more time, and sometimes can be difficult for some people. I'm not sort of, I mean, one employs all of them, but I'm saying that even if one stays with the point that you're making, Betha, of a traditional exam paper, and if you sort of ask for that traditional exam paper, what you put in that exam paper, what exactly is, it's not important that I am sitting there and asking those 20 questions and allotting half a mark to each of them. That's not what I'm supposed to do. If I'm giving you maybe an issue, maybe a problem, maybe something we've discussed over a period of time, and then ask you to reflect on it and give you a defined time saying this is 3 hours, one question, that's all you have to be doing.
Yeah, I agree with that, actually.
Yeah,
I think that's a good point, Amita. Even if you have a doctrinal question, you can actually have a critique and reflection question as part B of that, which asks you to reflect on whether there is justice delivered by this process that is actually available under the legislation.
What I'm saying is, Betha, once you recognize that the objective of your teaching is, I actually say it in the most, in some ways I can say in the most blunt or crude manner, is just to, help your students to think. That's the only objective of. Think on whatever you are teaching them. If that remains your objective and you're constantly driving your teaching in that manner, logically your evaluation will flow in the same way. Because I can't ask you to answer to something that I've not taught you, or what has not happened in the course. Like, let's say, because the taught has got a, it's kind of like there's a paternalistic relationship that is being put out between learners, I would say. But if you are saying that, okay, you're going to provoke thought there and saying, no, as law people, we can't have this kind of this degree of self-importance where we believe that we actually drive the world. It's important for us to learn that, yes, we may be making these instruments, but do they drive the world? So if the law is not driving it, what is driving it? And exactly what's the relationship between these? You start seeing your discipline in a more holistic manner. But the moment we sort of make it like that, okay, whatever comes in from the legislature is the law, whatever comes from courts is the law, and actually that's the operable law, when it is not so, we necessarily kinds of, live in this, to use Vijaya's formulation, in this kind of a mythological world, where we think that this is what is happening, and we don't want to be looking at what is in fact happening. And that's not the best way of doing either education or research. And research is about finding things, which exist, but people don't know about it. And our entire session today has been trying to say that, listen, if you have studied corporate law or you thought about it and you did not realize that so much else was happening, and you're sitting there and reading your Companies Act of whichever year, just look at the disconnect between what you have been studying as the law and what is actually the operable law in your field. For me, that's like a huge thing. I mean, it came through so clearly with every example that you put out. And I'm hoping, and Vijaya, like I said, it's like this is material the university is going to make available for anybody who's planning to do research. And though I don't know for what reason, we had a large number of people who had registered, but evidently some disconnect has happened or whatever. But I'm very certain that frequent people are going to come back to want to look at this video. And I think both Vasanthi and I were running it more almost like a panel discussion with you, sort of things. But and I'm sort of making, what should I say, honest disclosure that. But it's been a very, very rewarding morning for me, and I'm quite certain for Vasanthi too. And we, like I said, we've been sitting and trying to break our heads on how do we rework the teaching of labor law. You've given us one more item on the agenda, at least as a conversation with other corporate law colleagues, literally using your presentation as the starting point and then discuss from there. Because it is so powerful and so useful that, and I'm not saying it because I like you very much, which I do. But, it's like, it's like, sometimes you just need a window to. I think I never really comprehended. I had that aversion to corporate law and said, I don't have the, like for me that was like, okay, there's a certain, especially I suppose the very static way in which it was taught, even to me. When we studied, I mean, I had corporate management in my master's, and it was like just painful.
It was all about keeping minutes, and who gets to keep
It
what
was
minutes.
painful. I mean, I can't describe it.
I found my corporate law course because I said, okay, where I could never get a handle in the course. I mean, not even one.
Anyway, it's been absolutely delightful. Vasanthi, it's so nice to see you again. Amita, thank you so much for the invitation. I've really thoroughly enjoyed talking to both of you.
We've also thoroughly enjoyed it. And I suppose, like, somewhere one has to be, there is a larger pedagogic purpose for why we are doing these workshops. So, and we have a very vibrant website and people visiting the materials we put out. So, I mean, this will be, and especially because the conversation we had in the labor law thing, as well as what we've had today, there is this tie-up we're trying to make between that you can't sort of make research and teaching disjunct. If you've not been teaching people in a manner which is thought-provoking, you can't then suddenly expect that once they come to do their PhDs, they get some new avatar and they suddenly know that how they are going to do critical work if they've never done it before. It's a reality that we should confront. And especially, I mean, I'm sort of sharing because, there's a lot of pressure on the Indian Academy that, the quality of work that you turn out needs to be of a certain standing stature. I want people to understand that it will be of that standing and stature. For that standing and stature to happen, you can't sort of say, okay, when the person comes to do PhD, now suddenly that person is going to become a different person. It doesn't work like that. For no one, it works like that. I mean, I've not been allowing I had a large number of my undergrad students who wanted to join this, and I've kind of been turning it down. My reason for turning it down primarily was that I felt that people who've not had, these guys are anyway, have more exposure, more resources being put out for them. Others who've not had that opportunity should get it. So those two factors were dictating it, because then you have these youngsters, because they're N2 characters, they'll get 200 questions in the chat box, and and most of it will be maybe nothing that we really want to talk about. So anyway, it's been a really, very thankful to you, and I think I'll come back to you we're bound to get questions and other feedback subsequently. It's like, I think for both Basanti and me, it has been like a huge learning experience, and something which is going to help us a lot in the other work we're doing. And possibly we will explore the idea of doing that elective, and maybe have you join us long distance or something. But I really liked all the suggestions you gave us on, looking at the company's documents, learning how to read them. It's something which is so doable and yet can produce good quality work. That's something I would really want to pursue it more seriously, kind of stuff. So thank you, Vijaya. Thank you for all your effort and this morning's very happy conversation. And thank you, Vetaphilos, for being this very what should I say, diligent follower of the workshops. He wanted me to sort of have people give materials before, and I told him next year maybe, but not now. It's like asking for much.
My pleasure. Well, you everyone have a good afternoon. And thank you very much. Thank you very much.
Vijaya.
I'll connect with you soon. Bye for now.
Okay, bye. Bye, Vasanti.